That just reminds me as well to start recording the process, and the process will now be recorded so that we can send the contact details through to you at a later stage. Normally a day or two after the session, we send the recording through to you along with any other information. I will also, during the course of the presentation, be dropping some links into the chat box. So if you can concentrate on the Q&A box if you've got questions coming through. We also have our provincial managers on board. Sorry, before we go there, SACE CPTD points are generated in the process for educators, and we will put those through. That goes through to your file of continual professional teaching development, I think the T is. If anybody wants to correct me, please drop it in the Q&A box. You can correct me for what that acronym is about. I'm sure there's someone else that might get it right. And then our provincial managers, as I mentioned, they are available. Their contact details right around the country. We have presence throughout the country. We've got a wide footprint. So please get hold of the provincial managers if you need further information. What we're talking about today is mainly at an overall level, and it obviously affects everybody in the same way. But if you do need information, the provincial managers also have got information. Some of them are on board today as well, and I welcome them to also put comments in if they would like to add to the conversation through the Q&A box, to put some comments in as well, so we can discuss the processes as we're going forward today. And with that, I'm going to hand over to Jeanne straight away. Let me just click here. I'll hand over to Jeanne. Welcome, Jeanne. We were online during the Afrikaans session, so welcome to the English session, and thank you very much for your presentation. And I know you have got Carita in the wings as well today. So over to you, Jeanne.
Thanks, Paul, and good afternoon to everyone. I was hoping to say from a nice and sunny spring day here in Bloemfontein, but unfortunately, as you can see, it's a bit cold here. We're not experiencing our usual spring weather here in the Free State, but it's lovely to be talking to all of you this afternoon. Yeah, we're now at our third POPI presentation of our series of POPI presentations, and today we're specifically focusing on the role of the information officer as prescribed by the POPI Act. So for those of you who have attended our previous two presentations or our two sessions on POPI would have realized or would have recognized this first slide, and I always start with this slide, so please bear with me if you did attend one of our previous POPIA sessions. But for me, it's always important to just understand why we have this specific act and why we have the specific prescripts to keep the main goal in sight. It gives us an understanding and helps us to implement what the Act prescribes if we have the main goal and the main objective in mind. So very importantly, first of all, the right to privacy. Now, the right to privacy is not something that the POPI Act created. The right to privacy is something that is prescribed by our Constitution, and that's something that's been in place for quite some time. Now, what the POPI Act now does, it gives us guidance and it gives us specific prescripts that we must abide by to ensure that we do protect this right to privacy that a natural or a juristic person has. Myself as a natural person, the school as a juristic person, we all have this right to privacy, and we also all now, in terms of the POPI Act, now have the obligation to ensure that we do protect this right to privacy that every person has. Now, very importantly, we do have the right to privacy on the one hand, but on the other hand, we also have the right to access information. So we now have an obligation. We have to ensure that we do play this balancing act perfectly. Sometimes we're going to have to stand on the POPI Act to state, but we do have a right to privacy to protect, and we cannot grant access to information. Whilst on the other hand, sometimes a person might need specific information to protect an interest. And that's when we'll have to consider how do we balance these two rights, and when do we grant access to information. Now, in our previous presentations and sessions, we didn't really focus on the PIA Act. Now, the PIA Act is the Promotion of Access to Information Act. Now, today, due to the fact that the PIA Act also prescribes certain functions to the information officer, I'm going to refer you to the PIA Act throughout the presentation today as well. But I think it's very important that we do keep in mind that we do have an obligation to balance these two rights, and we must understand how to go about to ensure that we do that. Now, very importantly, why do we have the purpose of, or what is the purpose of the POPI Act? Now, the name of the Act actually gives it away. It's the Protection of Personal Information Act. So what the Act does, it states that if a responsible party is using personal information or is processing personal information, there is now an obligation to make sure that the personal information is protected. So that's the purpose that we must keep in mind if we consider and look at the functions and the obligations that the information officer has. Everything we do, we have to make sure that we work towards this purpose and that we do exercise and acknowledge this right to privacy that a person has. And then finally, the POPI Act regulates the processing of personal information through 8 conditions. Now, I'm not going to go into the detail of those 8 conditions today. If you've missed our previous POPI sessions, we do have a special POPI course which you can access through our FEDSAS e-learning platform to make sure you get up to speed as to what the 8 conditions are. But today I'm specifically going to focus on what the information officer's duty is. So very important, let's just look at the question as to who is the information officer. Now I have to point out that the information officer is not created by the POPI Act. It was actually created by the PIA Act in Section 1. So it's not a new thing for schools. And if your school does not yet or has not yet appointed an information officer, you're actually a bit behind schedule. And you need to get your ducks in a row and make sure that you do appoint your information officer. But what the POPI Act does, it actually now just expands on the role of the information officer. So there are specific obligations which the PIA Act prescribes. I'm going to refer you to those obligations throughout the presentation, but the POPI Act now just expands on that role. Now, if we look at the PIA Act and the POPI Act, the definition specifically states that if we look at a public body, that would be our schools, would resort under the definition of a public body. The CEO or the equivalent officer of the CEO would be your information officer. Now, the question arises whether that person would be your school governing body chairperson or would it be your school principal. Now, the CEO is busy with the operational or is responsible for the operational component of your organization. So if we compare that to your school, that would be the function and the duty of your school principal. Your SGB and your chairperson is, it can be compared to the directors and the direction of a company. So that's why it's important to please take note that the information officer, as defined by PIA and POPI, would be your school principal. Now, I know that our school principals already have a lot on their plate, and we don't want the information officer as the principal to lose focus from the core business of the school, being the academics. So that's why the Act makes provision for the designation and the delegation of functions to a deputy information officer. And on the next slide, I'm going to expand a bit on who must be considered as your deputy information officer. But I think let's just stand still and just look at what the Act prescribes as to how do we go about to appoint or designate your deputy information officer. Now, first of all, the Act prescribes that it must be in writing. So very important, make sure that when you appoint a deputy information officer, the information officer being the principal must make sure it is in writing. And then secondly, what is important is this does not exempt the information officer from his or her responsibility or power. So it remains the obligation, and it remains important that the information officer plays an oversight role and ensures and keeps an eye out to make sure that the deputy information officer performs the function as he or she is supposed to. And then also the deputy information officer, or the information officer may withdraw any functions delegated, or they may amend the functions that are delegated. So it's actually quite simple to appoint or to delegate to a deputy information officer, because the only requirement is that it must be in writing. But I have to point out now that there is a requirement that the information officers must be registered with the information regulator. Now, Carita is going to speak on the obligations and the duties of the information regulator a bit later on. But at this stage, I would like to point out that the information regulator is busy with the drafting of a policy which prescribes and regulates the process through which these information officers must be registered. Now, I have perused through the draft policy, and as it currently reads, it's actually quite simple. It's just an application form that you have to complete and then submit with the information regulator. Now, it does require the information of your information officer, the deputy information officer, and then your school as a responsible party. So that process is actually quite easy. And as the policy currently reads, there is a deadline of 31 March by which the registrations must take place. But FEDSAS will keep you in the loop, and we will keep you updated as to when we have a final policy, and we will keep you updated on the cutoff date by when you must register your information officer. So please make sure that you do keep a lookout for our FEDSAS newsletters in that regard. Now, I would like to share a few thoughts on the appointment of the Deputy Information Officer. Now, what the Act does, and that's the PIA Act and the POPI Act, it states that the most senior member of the organization would be your information officer. So, for me, that's an indication that this isn't something that we must take up lightly. It's actually someone who must be quite responsible, who are supposed to ensure that we do comply with these two acts. But the question actually is it appropriate to keep your most senior member of your organization busy with the requirements of this act? And my personal opinion is, if you are in a big school, we do know that our principals are already so busy, and we don't want to take away their time, their precious time, which must be spent on the core business of the school, which is the academics. So who do we consider now for this position of Deputy Information Officer? And in this regard, I'd say it's very important to look at some other senior staff members within your school. Perhaps your deputy principal, or someone which currently serving in an HOD post. So those are the kinds of persons that you must consider to see if they can assist the principal in bearing the weight of the POPI and the PIA Act. If you consider, and if you decide on someone, the deputy principal, for instance, it is important to make sure that that person gets the necessary training and gets up to speed on exactly what the POPI Act requires. The ideal person would be someone with a legal background, but unfortunately, as we know, we're working with educators, and I'm not generalizing, but usually they only have an education degree and not a law degree that goes with that. So very importantly, and in the coming slides, I want to refer you to the establishment of a committee and who must serve on that committee. But very importantly, we must ensure that that person is well trained and knows exactly what the POPI Act requires of him or her. And then also I can just also point out, you may appoint more than one deputy information officer to share. If you do have a big school, you can appoint more than one deputy information officer to assist in this regard. So what about outsourcing? I've had a few queries from a few member schools wanting to outsource this obligation now. Now, I just want to stand still and point out a few facts that we must consider when we look at outsourcing. First of all, it isn't prohibited by the law, but I want to ask the question whether it would be smart to outsource this obligation. Now, first of all, if we look at the processing of information within your school, your own staff members would be in the best position and understands the processing best. So no one from outside of your school are in a better position than you are to know how the processing of the information works. Then secondly, it remains the responsibility of the school self and of the information officer self to ensure that we institute the safety measures within the schools. That wouldn't be the obligation of the person to whom you've outsourced this obligation. And then thirdly, if you are a member of FEDSAS, we are actually serving as an outside source which you can turn to. And we have already developed all of the documents that you need to ensure that you do comply with the POPI Act. And we are available to give advice as you need it. So please, we're just a phone call away. So before you start outsourcing to external parties, please consider what I have said and please make use of FEDSAS and of our services because you have already paid for that. Yeah, so that's my thoughts on the appointing of the information officer. And I think it's important just to once again consider the information governance model within your school. Now, I have shared this slide in our previous sessions as well, but I do once again want to emphasize and just point out how our information governance model looks. Now, most of the processing of the information takes part right here at the bottom. That's where our personnel component is, and where we have our support component being our committees or our school management team. And right there on the top, we have our school principal being our information officer. So our information officer plays a vital role to ensure that everyone within this information governance model knows what the POPI Act requires of them and that they do receive the necessary training to ensure that where the processing takes place, that everyone abides by what the Act requires and institute the safety measures as decided on by the information officers and deputy information officers. And then I have not yet referred to our school governing body. In my previous slides, I did refer to the school governing body being the equivalent to as the board of directors. That's why the governing body wouldn't be the information officer, but the school principal, equivalent to the CEO, is responsible for that role. Now, just very importantly, which we should also take note of, is that the processing of information does not necessarily always stay within the school. Sometimes we outsource to a third party. I'm going to use these 6 as an example. We use these 6 to communicate to our parents. So there's now an obligation on your school's information officer to ensure that the necessary agreements are in place with your third-party service providers. The POPI Act goes so far as to say that if you make use of a third party to process your information, the school's information officer remains liable to ensure that that third party has the necessary security measures in place. So important, before concluding an agreement with a third party, please make sure and ask them about the safety and security measures that they do have in place to ensure the protection of personal information. And please make use of the FEDSAS agreement, which is available on our FEDSAS website, you'll see we've created a POPIA compliance toolkit where you will find the agreement which you can use when you look at the outsourcing of information to third parties. And then also the Department of Education. We are still in consultations with the department. And from FEDSAS' side, we want to make sure that the Department of Education also puts the necessary safety measures in place. And we want to make sure that they can also ensure and guarantee the protection of personal information which schools then eventually submit to them. Now, what is the duties of the information officer as prescribed by the POPI Act? Now, Section 55 of the Act prescribes exactly what those obligations are. Now, first of all, the information officer is responsible to encourage POPIA compliance. Now, in this regard, we do encourage all schools to make sure that they put and get the necessary POPIA policies in place, and that they do inform the bottom level of your information governance model of the POPI policy that you do have in place, and make sure everyone knows what is required in terms of that policy. So that's the first duty of your information officer. Secondly, dealing with requests. Now, you start to get a feeling as to why you don't want to keep your principal busy with these kinds of duties. Requests to have information updated or requests to access information. Those are the types of requests that your information officer would be responsible for. So that's something your deputy information officer can most easily deal with and handle. Working with the information regulator, Carita is going to refer you to instances where the information officer must work together with the information regulator. Interestingly, I can perhaps just point out, I've read in the Act, if personal information of children is to be outsourced to a third party outside of the borders of South Africa, you may only do so once you have obtained the information regulator's permission. So that's something that we must remember, and that's why the information officer must work closely with the information regulator. Ensuring compliance. Those 8 conditions that I referred to at the beginning of my presentation, it remains the responsibility of the information officer to ensure that everyone within the school complies with those 8 conditions. Then, if we consider a few other duties which may be prescribed throughout the Act, in the next slide, I'm going to expand a bit on those duties, so please just bear with me for a while. It's not just limited to these 4 duties that I have already mentioned. There's some other duties as well. And then finally, I also wanted to point out, I've highlighted here in red, there's also an obligation on the information officer as prescribed by PIA to report to the information regulator or request that the school received to access information throughout a year. So there's that additional obligation as well. So that's in a nutshell, what the POPI Act prescribes, what the duties of the information officer is. But based on that job description, I actually want to expand a bit on the responsibilities of the information officer. Now, very importantly, if we want to ensure that we can tick off all of the requirements as set out in Section 55, the information officer must develop an information governance strategies. Now, I do have a step-by-step compliance plan that I am going to refer you to how to go about to develop these information governance strategies. But it's very important that is one of the requirements and responsibilities of the information officer. And the information officer must advise and consult to school on privacy. So that bottom layers are feeling uncertain and unsure whether they are processing information correctly, they are going to return to the school's information officer. And that's also where FEDSAS is available. If you are feeling uncertain and if you are not sure whether you are now legally processing information, please contact us and we give the necessary guidance to you in that regard. Develop and perform privacy training and communications. Yes, we must ensure that our personnel and everyone that works with the personal information are up to speed, and that we do communicate clearly to them what is expected of them. Number 4 is to monitor and measure privacy compliances and enforcements. We want to make sure that we don't kick off with a bang and then a few months from now we forget about the POPI requirements and prescripts. We want to make sure that we keep this pace at within which we start throughout the year. Respond to privacy incidents. It's a requirement of the information officer, and it's an obligation and the responsibility of the information officer to inform data subjects if there was a data breach in our schools. And we've read now of the data breaches that has taken place at a credit bureau of South Africa with 24 million data subjects personal information now shared. So it remains an obligation of the information officer to keep the data subjects informed. Reporting to the SGB. The SGB is the body that must budget, that must ensure that if we need to update our infrastructure, that we put the necessary things in place to do so. So it is important for the information officer to report regularly to the school governing body. Performing risk assessment and data inventories, that goes actually hand in hand with the monitoring and the measuring of our privacy compliances. The developing and implementing of privacy policies, that in that regard FEDSAS has already done the basis. You must now just adjust to your school's need. And then administering privacy personnel and budgets. We must make sure that all of our personnel knows what our privacy policy prescribes and what is expected of them, and we must consider our budget. Now, if you feel overwhelmed by what I have said up until now, I want to use this slide to create a bit of calmness. Now, this slide would prescribes to you exactly how to go about and how to approach the POPI Act to ensure that you do become compliant. Now, the first step that you as an information officer must take must be to appoint a POPIA committee. So who must serve on this committee? Now, my suggestions is that, well, definitely and most surely your information officer and your deputy information officer. Also, please include legal advisors, seeing as we are dealing with the law and we are dealing with the POPI Act, it is advisable to include someone with a legal background. Now, if you don't have someone on your school governing body who has a legal background, please turn to your parents of the learners in your school to see and approach those persons to see if you can find a lawyer from your parents who can serve on your committee. Security and technology expert. Seeing as we are considering and we are doing risk assessments, we have to update and ensure we have security and technology safety measures in place. And that's why it's advisable to include someone with the necessary expertise in your committee as well. And then finally, a business process analyst. And that would be someone who knows the information governance model of your school very well. So include such a person. So this committee can get together and then go ahead with step 2. And step 2 would be our risk assessment. So in this regard, FEDSAS had developed an information security checklist, and it's our suggestion that you, as a committee, kick off with this risk assessment. So we have identified the 4 areas where we do believe the greatest risk lies, and that would be your physical security. If I can just expand a bit, we want to make sure that the infrastructure of your school provides sufficient security. Just a simple example, we don't want people going around walking freely into offices anymore. So if it is possible, consider consultation areas within your school's infrastructure where you can meet people and ensure that you protect personal information in such a manner. Digital security. That's where you want your technology expert to come in and advise the school, but you want to identify and use the security checklist to see where your security falls a bit short. And I also want to refer you to our FEDSAS Technology Centrum. Rian van der Berg, which is the head of our center, can provide guidance and refer you to products which you can use to ensure that you do tick that digital security box. So that's where you start looking at your antivirus programs, your firewalls. So that's the second area where you do have to do a proper risk assessment. Then considering your operational security, that's the personnel of your school. We want to make sure that everyone is up to speed and everyone knows what is required of them. We want to educate and train our staff to make sure that they password protect information that they share, which is of a personal nature, which they, for instance, save on a memory stick. That's the kind of things that you want to do there. And finally, our administrative security. We want to make sure that we do have the necessary policies in place. The leadership of our schools knows exactly what is expected of them. Your school governing body understands what the POPE Act requires. So please make sure of that risk assessment when you turn to step 3. And that is when you start looking at the solutions that you need to implement to address the risks that you have assessed. And with the budget right around the corner, now would be the ideal time to start doing this risk assessment. So you can make suggestions and recommendations to your financial committee, who must budget if for specific and additional security measures that you want to put in place at your school. And then the 4th step is when you have to start implementing solutions and when you have to do audits to ensure that the school remain compliant. As I've said, you want to ensure compliance all the time. So that's why it is important to do the audits and as the information officer who is responsible to ensure that the school and everyone within the school remains POPIA compliant. Now, with that being said, I want to refer you to our FEDSAS practical guide to POPIA. So I just want to expand a bit on what I haven't covered yet, which is also covered within our POPIA guide. Now, first of all, I have touched on the appointment of the information officer. I'm sure that after today's session, you would be able to identify the ideal persons. And just keep a lookout for our newsletters, just so we can keep you updated as to when the information must be registered and the process to follow. We will also make available the necessary forms that you must complete. And perhaps I can just point out that the policy that I did refer to a bit earlier on also makes provision and includes a specific form that the information officer can use to delegate and to appoint the deputy information officer as well. Now, our POPIA compliance policies, if you have not yet drafted or if you do not have in place a PIA policy, please also make sure that you visit our FEDSAS website. Additionally to the POPIA compliance policy, we have a PIA manual, which is required in terms of the PIA Act. Please make sure that you do get these policies in place. We've also developed a few additional policies, such as your not the cyber security, but ensure that your digital security, when you use your emails, when you communicate in a digital manner, that you do make use and make sure that those policies are in place as well. So that is also available on our FEDSAS website. We do make some suggestions with regards to the collection, retention, and securing of personal information. Now, our previous 2 sessions, we covered the requirements that or the prescripts of POPI, specifically with regards to the collection, retention, and securing of personal information. So if you missed that, please make sure to visit the FEDSAS website and go through the guide for some tips in that regard. Please make sure that you update your employment contracts. I have pointed out that there's an obligation on your staff and your personnel to ensure that they will protect the personal information. So we have revised the employment contracts, and we do encourage you to make sure that you update your employment contracts so that your employees can also realize and that they also understand the seriousness of the requirement of POPI to protect personal information. Your third-party duty, we have draft agreements which you can use in that regard. And then finally, we do, in this practical guide, you will find a link to our e-learning, FEDSAS e-learning page, where you can register for our POPIA course, which we do recommend for the information officers. Okay, then just to put your minds a bit at ease, the question as to whether the information officer can be held personally liable. Now, the only place in the PIA and the POPI manual where there is specific reference to the information officer being held personally liable is if the PIA manual was not created. So please make sure that you do ensure that you get the PIA manual in place if it is not yet in place at your school. I have to point out, I haven't heard of any information officer being criminally charged because of the fact that they don't have the PIA manual in place, but let's not take any chances. Make sure that you do get it in place. And then finally, I've just highlighted a few. Carita's going to refer to it in her presentation, where we look at fines and sometimes imprisonment, which the information, if found guilty, which the information officer can be sentenced to. That's just a few examples of criminal offences as prescribed by the POPI Act. And then finally, just to give you an idea, if you visit our FEDSAS website, this is the images that you will find on our FEDSAS landing page. If you click on the POPIA Compliance Toolkit image, it will take you directly to the page where you will find all of these documents. So please make sure and make use of the POPI documents. Now, Carita, if you are available, I do hope so. You can share your screen now. Now, Carita is also a member of our FEDSAS legal team. She just completed her master's degree on the POPI Act. So, Carita, it's a privilege to have you on board today, and we look forward to listening to you as well, and to expand a bit on our policemen who will be seeing to it that the information and that schools do comply with the POPI Act. So, over to you.
Thanks, Joanne. So I'm just going to give a short overview of the role of the information regulator in terms of POPI. Firstly, I suggest that you check out the information regulator's website. There are quite a few nifty sources and they keep it quite updated. The current information officer is Pansy Tlakula, and she was appointed in 2016 by President Zuma. And since 2016, the information regulator and the whole team behind that has been drafting and making guidelines to ensure that compliance be possible by next year. So in sum, if we have to sum up my part of the presentation in one sentence, it would be that the main responsibility of the information regulator is to monitor and to enforce compliance with POPI. So I'm just shortly going to give an overview of the powers of the information regulators in terms of POPI. Firstly is to provide training in terms of POPIA, to monitor and enforce compliance, to consult with interested parties. The information regulator also receives complaints, and I will deal with that in a little bit more detail. And the information regulator also has to do some research and then report to Parliament about POPI and personal information and the protection of personal information. And then also the information regulator publishes guidelines concerning codes of conduct. Oh, sorry, I see there's a typo there. I will also touch on codes of conduct later. And then when there is a need for the transfer of personal information across borders, the information regulator also comes into play, because other countries, they have their own privacy laws and standards about the transfer of personal information across borders. As mentioned, you can go and check out the information regulator's website. Several guidelines have been published, and you can also find those on the FEDSAS POPI page as well. POPI provides that the information regulator may establish committees if it sees that a committee is necessary for the proper functioning. In terms of POPI, one of these committees is must be established, and that's called an enforcement committee. I will talk a little bit more about enforcement committees when we come to the complaint section. But this committee consists of experienced people, as you can see on the slides, a High Court judge or a magistrate with 10 years experience, and an advocate or an attorney with 10 years experience. So that is a committee that must be enforced, and that must be established rather. Then the information regulator must or may establish from time to time, or publish rather, codes of conduct. In POPIA, Chapter 7 deals with codes of conduct, and the information regulator may also, in terms of Section 63D, issue a code of conduct that is aimed at a specific group, such as education. The information regulator may issue these codes of conduct on its own initiative, or it can consult with stakeholders or a body representing a specific group of people. When that happens, a notice is first published in the Government Gazette. So these codes of conduct sets out the conditions for lawful processing, and if it is in a specific sector that has unique characteristics or such, it must prescribe how conditions for lawful processing will be complied with by that sector. You can also apply for a code of conduct to be issued, and the regulations make provision for that. Form 3, that is attached at the end of the regulations, is a form that must be filled out, completed and submitted to the information regulator should you want a code of conduct to be issued. Now we can get to the dealing of complaints by the information regulator, which can be found in Chapter 10 of POPIA. So you'll see here on the very short summary, there are 7 different types of things that can happen in reaction to a complaint. These aren't steps, they don't follow each other. It really depends on the specific situation. Firstly, a complaint is made by any person. It must be written, and it must be on a prescribed form. This is Form 5, which you can find also attached to the regulations, which are also on FEDSAS website. So firstly, the information regulator can look at the complaint, maybe do an investigation and see that no action is necessary. That is an option. Secondly, the information regulator can try and conciliate, to act as a conciliator. So get the parties together in a meeting, see if we can settle this. This is called a conciliation meeting. And at the end of the meeting, the information regulator issues a certificate that says conciliation was successful or it wasn't successful. And if it wasn't successful, the information regulator then continues with an investigation. The third option is settlement. This is a lot like conciliation. And the information regulator can try to settle this matter if they have reasonable assurance that the conduct that's being complained about is not going to be repeated. Then the information regulator also has powers to do a pre-investigation. Then the information regulator notifies all the parties that it intends to do a full investigation, notify them of their rights, notify them of the details of the complaint. During the investigation, the responsible party also has the right to give a written answer. And after the investigation comes a full investigation, and here the information regulator has quite a wide range of powers to gather witnesses and evidence and to decide if it is relevant. And this is comparable to the powers of a judge in the High Court. It can interview people in private, administer oaths, and issue warrants, for example, be summoned to appear to give evidence, and also enter and search premises. And then the information regulator can also refer the matter, the complaint, to an enforcement committee that I mentioned earlier. This enforcement committee then is informed by the information regulator of the manner of which the specific party should come and give evidence in front of said committee, and the period for investigation, and when the report must then be given to the information regulator. And lastly, the information regulator might see that this matter is not to be dealt with by them. For example, they may not have jurisdiction, then they will refer it to another regulatory body. Then, in terms of Section 89 of the information regulator may decide to conduct an assessment itself, or a request may be submitted to the information regulator to make an assessment, and this assessment assesses the compliance with POPI. So during the assessment, then a report is written, and then an information notice can be issued. This information notice can tell the responsible party, this happened, this is what we found, and please stop with this conduct, for example, within 30 days. This report that is given after an assessment has the same power as an enforcement notice. Now, an enforcement notice, and more information on that in Section 95 of POPIA. So an enforcement notice is issued by the information regulator after considering the report from the enforcement committee. So the enforcement notice is delivered to the party saying, stop with this, or please start with this in terms of POPI. But the responsible party receiving such a notice, they do have the right to appeal. Civil remedies, that's found in Section 99 of POPIA. And this is, so a civil remedy is a claim for damages that was suffered, but that's not criminal in nature. So a person may request the information regulator to institute a civil case in a competent court. However, there's quite a few defenses for the responsible party to make use of in that instance. The information regulator and the information officer, as Jonay said, have quite some of that collaborative relationship, especially in terms of investigations. If there is an investigation taking place, it's really not a relationship of a policeman watching over, but truly to work together to make sure that the purpose of POPIA is fulfilled. I'm going to start by concluding my section. Very quickly about enforcement of POPIA, which through what we have spoken about, an enforcement notice or an information notice, but if this continues, then and enforcement is an option in terms of POPIA. So to sum up slides, basically a magistrate court can order that a fine be paid or that imprisonment take place, and if I would have to summarize this whole table, it could be that any person that sort of obstructs the information regulator's duties. There's also a whole section about an account number. That's a unique identifier given to a person by a responsible party. You're not allowed to sell that or to use someone else's. Then, lastly, my last couple of minutes, and there's also an administrative fines that the information regulator can give to people who have allegedly committed an offence in terms of POPI. Then a violation notice is issued. So this notice contains details of the alleged violation and then an administrative fine. So this notice basically says that you have to comply with this notice, otherwise a fine will be payable. So these fines, in terms of section 109 to subsection C, may not exceed 10 million rand, and then the responsible party which receives an administrative fine, they can arrange for a down payment, and they can appeal and prefer that this be heard in a court of law. And that's my story with regards to the information regulator. I'm going to give over to Paul or to you, Anna. Thanks.
Thanks very much, and thanks for that information, Carita and Jeanne. I think it really starts putting the whole process in a better format and a better package, if I can call it that, so we can understand a little bit more about what we've got to do in the next few months. There was one question that just popped through, Jeanne. I don't know if you can see that on the screen now, just with regards to the information officer. Yeah, maybe if you wouldn't mind taking us through that one. Carita, you can put your screen on or your video on. You've disappeared from sight. It'd really be nice to have you on board. There we go. Excellent.
Okay, yeah, thanks, Paul. If I can answer this first question as to the legal action which would be taken against the information officer, as I have pointed out, it's just actually the Act only speaks to the actions taken against the information officer if you don't have the PIA manual. And the action would actually be taken against the school as the responsible party. And that's where Carita referred to the enforcement notice. I think, first of all, we'll see how strict our information regulator is, but I think we kick off with an enforcement notice, like hitting the school a bit over the finger, stating, no, you have to comply or you have to start doing this. And if you're not complying, as Carita also referred to, we'll start looking at the violation notice, and that's where we start to see the fines coming in. So yeah, I don't think you'd have happy parents if you have a 10 million rands fine, which the school fees now has to pay. But I think unless the information officer is grossly negligent in the way he or she goes about in their dealings, it would be the school as the responsible party who would be held responsible. Carita, something you want to add on which I've missed?
No, I just think coming from a sort of a civil law, if it's like the worst case scenario and the responsible party must pay a fine or damages in terms of a civil remedy in terms of section 99, they can always claim that back from a third party who, yeah, but that's now, if this is like worst case scenario, lawyers get involved. Yeah, but I also think we should wait and see how strict Pansy Takula will be.
I think if I just look at it from a pure governance viewpoint, and I'm a serving governing body chairman at a school, I think the important thing is let's not focus on what might happen if we don't do things. Let's rather get the processes in place. Let's rather concentrate on protecting the information. Let's do those checks. Let's do that monitoring. Let's see where the risk lies with the information. Let's rather do that than worry about how big this fine might or might not be and how it's going to be implemented. I do often say to schools that often you are managing your information already. You just need to now do it in a more uniform approach. There's now a guideline approach as to how it's got to be done. So that's from a practicing chairperson of a governing body or a serving chairperson. I think it's important that we just do the right thing without worrying about how big the stick is that's going to come down to us down the road. But I'll have to say that, and we said that in the beginning as well, is July 2021 is not far away, folks. So let's make sure we actually start doing things rather than wait and scrambling as we go down the road. If there are any other questions, you're welcome to please drop them in the Q&A box. I'm just going to go through the last few slides just to remind you about our website. Please make sure you visit it fairly regularly. There's always new information going through. I have dropped in the chat box the details with regards to the POPIA checklist and the details that are on there with regards to POPIA. And then just a quick reminder, I'm going to drop a note now if I can get it right while I'm trying to do two things at once here. I'm going to just drop a note in there of our link to the e-magazine. So if you wouldn't mind picking up that, it's a wonderful magazine that comes out sort of periodically once we get a lot of information together. And there's a lot of information sitting there which is going to help you on your information process. And we start talking about there, one of the headline articles there is the Chief Information Officer. And I think it's really important that we have a look at those details. It's not a bedtime read. It's a coffee book read type book, but it's got a lot of information, and a lot of organizations that are associated with the Center of Technology are showcased through that process from there. And then this is probably our last planned webinar. It sounds like we don't know what we're doing when I say that. We have got a few others lined up and coming through in the process, but we had a bit of a run to try and catch up. President Ramaphosa created a bit of chaos in our lives as well. So we've had a bit of a run to actually get to where we wanted to at this point. We do try and bring you webinars that are relevant to the time that they need to be brought to you. And we're busy working on the next round. So that at the moment is under construction, but please feel free to get hold of us. We've now got a lot of source material. If there is information that you're coming across, please get hold of your provincial managers. They've got access to that information as well, and they can then provide you further information beyond this topic, but other information as well. So please make sure you've got their details there. And then lastly, thank you very much, ladies, for your involvement today. Thanks very much. It was Carita's first run. Sorry, I'm just going to wait for the internet to stabilize a bit there. It was Carita's first run. First run in Afrikaans, we had a bit of a sound issue. This run, there was a clear run, so it was really great. So finally, I'll give one of you the opportunity to say the final word. Thank you very much for your involvement, and we really appreciate you being on board.
Thanks, Carita. I think let's have you, if you won't mind, you can have the last word today.
Very much. Thanks everyone for joining. And as we've stated many times, if you have any corporate questions, please don't hesitate to contact FEDSAS. We are here to help. And thanks, Paul, for making sure everything runs smoothly.
Super. Excellent. Have a good afternoon and good evening, folks. Cheerio.
Thanks.